Good morning, everyone. We're in first appearance court. My name is Judge Jackie Powell, and we're in the courtroom this morning. We have a representative attorney from the State Attorney's Office, Mr. Eric Linder, the attorney from the Public Defender's Office, Mr. Brian Reedy, and at the jail, we have the attorney from the Public Defender's Office. I believe it's Mr. Hector Romero. Also in the courtroom, we have pretrial services, confinement status. We have the clerk's office and or courtroom bailiff. Today is not your trial. Today is your first appearance. We're going to make a determination as to probable cause and then a determination as to your release. Everything in this courtroom is recorded. So everything you say is being recorded. So if you are represented by an attorney, I would recommend that you speak with your attorney before you speak on the record. If you have an attorney, your attorney will speak on your behalf. If you have not retained the services of the public defender and you have a private attorney, when you come up, you can certainly let me know that. And if you have already spoken with that person, you can let me know what you wish to do. And so we will begin our docket this morning. Tony Clifton Lester. And when I call your name, just please come to the podium.
Good morning, Judge.
Good morning, Mr. Lester.
Yes, ma'am.
You're before the court today for an out-of-state felony hold. You will be going before the extradition court. Thank you. Rebecca Ann Crow.
North Broward, Your Honor.
Thank you. Good morning, Ms. Crow.
Good morning.
You're before the court today for petty theft. The court does find probable cause.
Your Honor, I'm going to ask the court to leave the bond in place at $100. Ms. Crow has a couple of no bond holds on counts 1 and 2.
Thank you, Counselor. And your bond is $100. Thank you. Merica Janacia Patterson.
Also North Broward. Ms. Patterson would like to resolve this matter if possible.
Okay. Good morning, Ms. Patterson.
Good morning.
You're before the court today. There are two misdemeanor capious charges that are pending before the court for two petty thefts. Your attorney, the court does find probable cause. Your attorney tells me that you would like to resolve these cases today. Is that correct?
Yes.
State?
Your Honor, the offer be withhold in court costs on each case.
You'd like to do that, Ms. Patterson? No conviction on your record and the time that you've spent in jail and court costs.
Yeah.
Okay, Ms. Patterson, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yeah.
You may put your hand down. Is anyone forcing you to resolve your case today?
No.
Are you under the influence of any alcohol or drugs?
No.
Have you ever been treated for a mental or emotional illness?
No.
Do you understand the proceedings today? Do you understand what's going on today?
Yes.
Okay. Do you understand that you're waiving your right to a trial?
Yes.
Do you understand that if you're not a U.S. citizen, you could face deportation?
Yes.
Are you pleading guilty or no contest to the two charges of petty theft?
Yes.
What is your plea? Guilty or no contest?
Guilty credit time start.
No. That is, no, you've got to enter either a guilty plea or a no contest plea.
Guilty plea.
When the court accepts your plea and find that it is freely and voluntarily given, you will be sentenced on both counts to withhold adjudication and court costs. Court costs is $293. Do you need time to pay?
Yes.
Then the court will give you 6 months to pay your court costs, Ms. Patterson. Good luck.
Okay. Good luck, Ms.
Yes.
Patterson.
Wilhelmina Joanne Holmes.
Miss Holmes is here, present judge at Maine. She is approaching. Come on up, ma'am.
Good morning, Ms. Holmes.
Good morning.
Ms. Holmes, you're facing count 1, drug paraphernalia, and then there is count 2, which is also a misdemeanor capias for petty theft. The court does find probable cause.
Thank you, Judge. And speaking of Ms. Holmes, Judge, I did tell her some of her options today, but she advised me that fortunately she got employed and she was supposed to start a new job actually today at Betty's Restaurant. Having said that, Judge, I don't think she's in a position to post her bond, but she did advise me. She wanted me to ask the court if the court would consider resolving both counts 1 and 2 today.
Your Honor, the offer on count 2, the theft, would be an adjudication 5 days in county jail. She pled out 2 thefts in Broward last year, and she has other theft priors from multiple states.
Judge, she really much wants to resolve the case, and she doesn't want to lose this job that she was just fortunate to get. I would be inviting the court into plea negotiations in exchange for her no contest plea. I would ask the court to consider extending an offer of a time served so she could be released, so that she could get that.
Are there, as to count 1, are there prior drug charges?
Yes, she does have prior drug charges, Your Honor, and I'm also showing a warrant out of another state on a drug offense.
Okay, Ms. Holmes, if you wish to resolve your case today, the state will, the court will sentence you to adjudication and time served on both counts.
Judge, I believe she wishes to accept this court's offer.
Okay, then Ms. Holmes, will you please raise your right hand?
Your right hand.
Do you have any children?
That's okay, we all make that mistake. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down. Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any type of alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
No.
Do you understand the proceedings today?
Yes.
Do you understand that you're waiving your right to a trial?
Yes.
Do you understand that if you're not a U.S. citizen, taking a plea could subject you to deportation?
Yes.
Are you pleading guilty or no contest to the drug paraphernalia charge and the petty theft charge before the court today?
No contest.
Then I accept your plea. I find that it is freely and voluntarily given. The court will sentence you to an adjudication and time served, credit for time served, on both counts. There is a court cost of $293. Do you need time to pay?
Yes, ma'am.
Then the court will give you 6 months to make your payment for your court costs. Yes, concurrent. Yes, yes. Count 1 and count 2 sentence runs concurrent. Thank you. Brittany Monet Foster,
She's in Paul Ryan, Your Honor. She'd like to resolve this matter today.
okay? Good morning. Good morning, Ms. Foster. Ms. Foster, you're before the court today for trespassing on occupied structure. The court does find probable cause. It is my understanding that you wish to resolve your case today.
Yes, ma'am.
State, do you wish to be heard on this matter?
The offer would be time served, no return.
Okay, Ms. Foster, the offer is adjudication and time served. Do you wish to resolve your case with that sentence today?
Yes, ma'am.
Then will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Is anyone forcing you to resolve your case today?
No.
Are you under the influence of any alcohol or drugs?
No.
Have you ever been treated for mental or emotional illness?
No.
Do you understand the proceedings today?
Yes, ma'am.
Do you understand that you're waiving your right to a trial?
Yes.
Are you pleading guilty or no contest to this charge today?
No contest.
Then, Ms. Foster, I accept your plea. I find that it is freely and voluntarily given. I sentence you to an adjudication and credit for any time served on this matter. There is court costs, $293. The court will give you 6 months to pay your court costs. Thank you.
Your Honor, I'd also ask for an order of no return.
And don't walk away yet, please.
Okay. Yes, ma'am.
Ms. Foster, I'm advising you not to return to the Grisham Apartments, 400 Northwest 4th Avenue in Pompano Beach. Do not go back to that location.
I won't.
Thank you. Shabria Melvins.
North Broward.
Yes, good morning.
Good morning, Ms. Melvins. You're before the court today for one count of battery on a law enforcement officer. The court does find probable cause. Does anyone wish to be heard as to the bond?
Yes, Judge, Miss Melvins is not going to be able to make any monetary bond. She indicated to me that she does not have any money and does not have anyone in the community that's going to be able to assist her. The only way that she can possibly get released from jail would be through pretrial release without the necessity of posting a bond. And I would ask the court to consider that.
Your Honor, my concern is she was arrested a little less than a month ago in Dade County for battery, and that is still pending. And now she's before the court allegedly striking a police officer in the face. I'd be requesting a $1,500 bond.
There's no way she's going to be able to make that bond, Judge, and in reviewing the probable cause affidavit, I realize it says that she became extremely irate and refused to comply with any lawful commands, but it doesn't say what those lawful commands are. And then the next thing you know, the officers are trying to put handcuffs on her, and it's only after that that the alleged battery takes place. So I'm not all that clear on exactly what grounds the officers had to arrest her in the first place. And I realize that's probably an argument for another day, but I think it is something the court can take into consideration.
I don't think it is something the court can take into consideration. Even if for some reason, and Mr. Reedy is well aware of this, even if for some reason the court found that there were no lawful grounds to arrest, she can't commit a battery against a law enforcer. You can't resist with violence, and you can't put your hands on a police officer or anyone.
Thank you, counselors. Ms. Melvins, the court does find probable cause, and the court will release you to the pretrial service supervision. I'm going to ask that you call in once per week. We're going to increase it. So you must report to pretrial within 24 hours of your release. And you must, it's going to be every week that you call into pretrial services. Do you understand?
I understand about the reports, but I do not understand in reference to what pre-trials is.
They will the deputy will give you the instructions as to where to go, and when you report to pretrial, they will give you further instructions. Thank you.
Thank you.
Aisha Portia Harris. Aisha Portia Harris.
She's here present, Judge, at Maine.
Good morning, Mrs. Harris. You're before the court today, count one for operating without a valid license. 2, failure to register motor vehicle. 3, attaching registration license plate not assigned. 4, failure to provide liability security. 5, child restraint required. And then there is a felony probation violation. So the court will leave the bonds in place as to count one, and then you will make no other changes, and you will be going to your felony judge.
On Monday at 8:30. Thank you,
Is
Judge.
it Monday? Thank you. Roberta Huha,
She's at North Broward, Your Honor.
thank you. Good morning, ma'am.
Good morning.
You're before the court today, count one, possession of heroin, count two, drug paraphernalia, and then there is a misdemeanor capias that's also outstanding. That capias is for driving while license suspended. The court does find probable cause. Does anyone wish to be heard as to the bond?
Your Honor, I'd ask you to leave the bonds in place. I spoke with Ms. Huha's bondsman, and she will be bonding her out.
Thank you. Then the bond remain, possession of heroin, $1,000. No action on the drug paraphernalia, and then there's the $500 on the capias. Thank you.
Thank you.
Brandy Bonsek,
Your Honor, she's in downtown courtroom 5750.
okay, so she's probably before her felony judge. Is Ms. Bonsek represented by the PD?
If she wasn't before, I'm sure that when she gets to her division judge, she'll be appointed at that time.
Okay, so, all right, so we'll take no action on Ms. Bonsek. Thank you. She's in her felony courtroom today. Derek? Well, Mr. Reedy, as to the, not the probation count, but do you want me to find do probable cause in absentia?
You can find probable cause,
Okay.
Judge.
And the court does find probable cause, and
I reviewed the probable cause affidavit.
thank you. Derek Theodore Cooper,
He's here present, Judge, at Maine.
good morning, Mr. Cooper.
Morning, ma'am.
You're before the court today for count one, a petty theft, and there's 2, 3, and 4. There are misdemeanor capiases, resisting obstruction without violence, trespass. The court does find probable cause. Does anyone wish to be heard?
Yes, Judge, my understanding is as far as count one, the petty theft is from a Home Depot in which the merchandise was recovered, so there's no restitution issues. Having said that, I spoke to Mr. Cooper. He wishes to ask the court if the court would consider resolving these matters today.
I would. Does the state have an offer?
The state's offer on counts 1 through 3, obviously I can't make an offer on 4, would be an adjudication 5 days county jail. Mr. Cooper, in addition to these cases, has an open burglary conveyance, possession of burglary tools, paraphernalia, and theft. This is just out of Broward. 2012, possession of cocaine, tampering with evidence, VOP, 51 and a half months state prison. 2 more possessions of cocaine in 2010, VOP, 51 and a half months state prison. 07, possession of cocaine, 3 years state prison. 07, possession of cocaine, 3 years state prison. 04, possession of cocaine, VOP, 18 months state prison. 04, possession of cocaine, same sentence. It goes on from there, Your Honor.
The court would resolve these cases, but there's also the city ordinance matter.
Correct.
Do we want to wait for that representative to come so that we can resolve that? Because otherwise, that's just going to be sitting out there.
let me talk to Mr. Cooper.
Okay. We can recall it, thank you.
Oh, no, we're,
Oh. Go ahead.
Judge, I believe Mr. Cooper, I just spoke to him briefly, Judge. I believe his intention was to resolve all the matters. So I don't know if the court would want to inquire on Mr. Cooper if he would want representation on count 4.
Mr. Cooper, do you need representation on count 4 to resolve that matter?
No, ma'am.
Okay, so, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
Yes, ma'am.
Do you understand the proceedings today?
Yes, ma'am.
Do you understand that you're giving up your right to a trial?
Yes, ma'am.
Do you understand that if you're not a U.S. citizen, you could face deportation?
Yes, ma'am.
Are you pleading guilty or no contest to the charges today?
No contest.
Then the court accepts your plea, find that it is freely and voluntarily given. Counts 1 through 4, the court will sentence you to an adjudication, 5 days, the Broward County Jail, credit for any time served.
One moment, Judge. I just wanted to make sure that Mr. Cooper understood what was happening as far as the offer from the state. Judge, I apologize, and that's probably my fault. I believe Mr. Cooper was under the assumption that we were requesting time served, and he thought that's what the court was going to extend a time served. I just informed him it's not a time served, it's a 5-day, so I just want to make sure that he wants to go through with this, now knowing what's the sentence going to.
Okay?
Yep.
Thanks.
Judge, respectfully, at this time, Mr. Cooper does not wish to resolve the case and does not wish to accept the state's offer. So at this time, I'm going to ask the court just to leave
Then
this matter alone.
the bonds will remain in place. Thank you.
Thank you, Judge.
Clinton George Tripp.
I've been advised he's in regular court, Judge.
Okay. Is Mr.
5750, Judge. Room 5751.
Okay. Is he represented by the public defender's office? Do we know?
I believe this is a new charge, Judge, so
Okay.
he probably didn't have an opportunity to fill out a PD application.
All right, then we'll take no action on Mr. Tripp. Thank you.
I don't know if you wish to reset it, though.
We'll reset.
Beautiful.
I'm sorry, we'll reset. We'll be reset for tomorrow.
Thank you.
Richard J. Crump.
Mr. Crump? Mr. Crump? Judge is calling. He's approaching, Judge. It's a municipal ordinance case as well, Judge.
Yes. Good morning, Mr. Crump.
Morning.
You have a municipal ordinance violation. The court does find probable cause. What do you wish to do, Mr. Crump?
Excuse me.
What do you wish to do with your case?
I'd like to resolve it today.
The court, will sentence you to an adjudication and time served if you want to resolve your case.
Yes, ma'am.
All right? Then, Mr. Crump, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Is anyone Are you under the influence of any alcohol or drugs today?
No, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
Do you understand what's going on right now?
Yes, ma'am.
You understand that you're waiving your right to a trial?
Yes, ma'am.
Are you pleading guilty or no contest to the municipal
No.
ordinance?
No contest.
Then, Mr. Crump, I accept your plea. I find that it is freely and voluntarily given, and I sentence you to an adjudication and time served. I'll give you 6 months to pay your court costs. I believe it's $78.
How much?
78?
Okay, yeah, I'd take a little time.
Okay, Mr. Crump, good luck. Timothy Powell.
Yes, ma'am.
He's approaching, Judge. Come on up, sir.
Good morning.
Good morning, Mr. Powell. You're facing count one, operating without a valid driver's license, and then count two is a KPS traffic matter. Thank you. The court does find probable cause. What does Mr. Powell wish to do today?
Judge, he wishes to resolve these matters today.
The state wish to be heard?
Your Honor, the state's offer is withholding court costs on each case.
Okay, Mr. Powell, do you understand that if you take a plea today, you'll be sentenced to a withhold adjudication and court costs? Is that what you wish to do?
Yes, ma'am.
Then, Mr. Powell, please raise your right hand. Hold on. Oh, do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you may put your hand down. Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
Do you understand the proceedings today?
Yes, ma'am.
Do you understand that you're waiving your right to a trial?
Yes, ma'am.
Do you understand that if you're not a U.S. citizen, you could face deportation?
Yes, ma'am.
Are you pleading guilty or no contest to the charges today?
No contest.
All right, then I accept your plea and I find that it is freely and voluntarily given, and I sentence you to withhold and court costs on both counts. The court will give you 6 months to pay your court costs. Good luck, Mr. Powell. Thank
Good luck,
you.
Judge.
Jeffrey Gramer.
He's approaching, Judge. He's here at Maine.
Good morning, Mr. Gramer.
Morning, Your Honor.
You're before the court today for a DUI or alcohol first offense. The court does find probable cause. And what does Mr., and then the court will leave the bond at $500.
Judge,
Unless-
I'm going to ask you, I haven't had an opportunity to review the PC affidavit. Mr. Kramer was telling me a little bit about the facts of the case, but first, before I get into that, my understanding is this is his first arrest. If the state can confirm that, I'm going to be asking for an ROR, and I'll see if the state has an objection to that.
I don't, Your Honor.
Then I will impose an ROR at this time. It's fine. Thank you. Geronimo Duque Escobar.
Mr. Escobar, come on up.
Mr. Escobar's bond has been posted, is what I've been advised. So the court finds probable cause and his bond's posted. Thank you. Gerant Porha.
He's here present, Maine, Judge.
Good morning. Sir, how do you say your last name?
Portia, ma'am.
Porja.
Good morning.
Good morning,
I wish
Mr.
you have-
Porja.
I wish you happy New Year and hope this is gonna be a blessed year to you and your family, ma'am.
Thank you. Same to you.
Thank you, ma'am.
Mr. Porja, you're before the court today on count one, resisting officer without violence, and then count two, trespassing. The court does find probable cause. And does anyone wish to be heard as to the bond?
Yes, Your Honor. Normally, I don't make a request like this, but based on these facts, I'm gonna be requesting $1,000 bond on count two, pretrial release with a GPS monitor. Your Honor, I am concerned for the alleged victim in this case. This was someone's home, according to the report. One moment, Your Honor.
I read it.
Okay, well, I mean, he's an ex of, I believe, 2 years. He advised he drove down from New York to speak to her. A couple days prior to this, the victim had to call law enforcement to have him removed from her property, and he told law enforcement at this time, he's not gonna leave, he's going to keep coming back unless she gets an injunction against him. So, I'm taking him at his word.
Mr. Porja, do you have a local address?
Currently, no, ma'am. Currently, like, I just moved back from New York, and honestly, like, I went with.
Don't talk about the facts.
Okay.
Judge, that's what Mr. Porja, hold on. Judge, that's what I was saying, Mr. Porja, about. He came from New York, but basically he's been coming back and forth from New York for a long period of time. He's 25 old. He has family that lives here locally. He did advise me he will abide by the court's order as far as no return, no contact, so he will adhere to the court order. My understanding is I believe he has very, very limited contact with the criminal justice system. So normally I would be asking for a straight ROR, but in this case, because of the state's, I guess, worries, I'm just gonna ask you to leave the standard bond in place. I know Mr. Porja is gonna, be abiding by the court order, so that should alleviate the concerns. So I'm just gonna be asking for the standard bond to remain in place at this time, Judge.
And Your Honor, I'm concerned that just because the court orders him to stay away, that he will follow that direction. He was just arrested last month for another trespass at a local restaurant in Fort Lauderdale, where he was causing a disturbance. He took an aggressive fighting stance, clenched his fist. He got into his car. He circled the block several times, refused to leave. He continued arguing. He was given a trespass warning. He left, and then he came back again. So he has shown in that instance and in this instance, when he's instructed to stay away from a certain place, he refuses to do so.
Thank you, counselors. The court does find probable cause. As to count one, resisting officer without violence, the court will impose a bond of $1,000. As to the trespassing of the property, it will remain the same. The defendant will also be on under pretrial supervision. There shall be no contact with Evelyn No Godula. And Mr. Porja, you must remain 500 feet away from Ms. No Godula. Thank you.
Are you gonna put him on stage or do you want a GPS?
Yes, level 2 GPS, thank you.
Judge, would you reconsider as far as the aspect of just the level and at the end of the day, this is a misdemeanor offense. He doesn't have a severe record. I think maybe pre-trial with level 2 GPS, those services maybe are probably more appropriate for other types of cases. I'm just asking standard pre-trial, the $1,000 bond then.
Denied, Mr. Romero, thank you.
Thank you.
Your Honor, you only want him on GPS for count 2 or?
For count 2. Thank you. Travis Sentinel Williams,
I've been at, North Broward, I believe, Judge.
thank you. Good morning, Mr. Williams.
Good morning.
You're before the court today for count 1, possession of cannabis, 20 grams or less, and count 2, petty theft, which is a first offense, second degree. The court does find probable cause. Mr. Williams, do you have an attorney?
Yes, Judge, I spoke with Mr.
Okay.
Williams. He's gonna be asking the court to consider releasing him on his own recognizance on count one. He's been a resident all of his life. I don't know if the state objects.
Well, no, one moment. My concern is he just pled out a theft a couple of months ago, and I'm also showing he has a warrant at a Dade, a $1,500 warrant at a Dade County for a theft for failing to appear in court, and that was issued last July. So I would be objecting.
Is that holding him?
It's not extraditable. My point is that he's shown, he was arrested in Broward in August of last year for failing to appear in court. Now he's got a warrant for failing to appear in court. He shows a history of not going to court.
Judge, he's been a resident all his life. He lives with his grandmother. Unfortunately, he has some issues that prevent him from becoming employed and saving up any money to bond himself out. He does not believe that his grandmother's going to be able to post a bond for him. So I would ask the court again for an ROR on this.
As to count one on the possession of the cannabis, 20 grams or less, the court will RR Mr. Williams on this count, and then the petty theft will remain with no bond set.
Thank you, Judge.
Garin Derville Guerriere. Good morning,
Broward,
sir.
Judge.
You're before the court this morning for false ID given to a law enforcement officer. The court does find probable cause. Does anyone wish to be heard as to the bond?
Judge, I don't believe he's going to be able to make that bond. I was going to ask the court for an ROR. He has lived in Florida all his life. He lives with his brothers and sisters. He's given me the number of his brother to call, but he's not sure that the family's going to be able to come up with any monetary bond.
Your Honor, I'd be objecting to ROR. He has 12 prior failures to appear, and in this instance, he's giving a false name.
Thank you. At this time, the bond will remain in place at $100. Thank you.
All right, I'll call your brother for you.
Geronimo Bouvet.
He's here approaching Judge of Maine.
Thank you.
Sorry, follow me.
Good morning, Mr. Bouvet. You're before the court today on 3 traffic capias violations. The court does find probable cause. What does Mr. Bouvet wish to do with his matters?
Judge, he wishes to resolve these cases.
Does the state have an offer for Mr. Bouvet?
Yes, Judge, the documented offer from the state is a withholding court cost on all counts.
Okay. Mr. Bouvet, did you hear that? The offer
He
is
wishes to
withheld.
accept the state's.
Okay.
This is my daughter, man.
Mr. Bouvet, can you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any type of drugs or alcohol?
No.
Have you been treated for a mental or emotional illness?
No.
Do you understand the proceedings today?
Yeah.
Do you understand that you're giving up your right to a trial?
Yes.
Do you understand that if you're not a U.S. citizen, you could face deportation?
Yes.
Are you pleading guilty or no contest to the charges today?
No contest.
Then, Mr. Bouvet, I accept your plea, and I find that it is freely and voluntarily given, and I sentence you to a withhold and court costs on all counts. Thank you. It's all one case, yes. It's one case. No, it's three different cases. Isn't it?
I believe it's the same case number, Judge, 3 counts.
Oh, I thought the third one was, okay, so it is one case. So it's one case. Yeah, yes, on one. Thank you. Yeshua Israel Holland.
He's here, President Maine, Judge.
Good morning, Mr. Holland.
Good morning.
You're before the court today. I believe it's a traffic KPS operating without a valid license. The court does find probable cause. What do you wish to do, Mr. Holland?
He wishes to resolve the case today, Judge.
The state wish to be heard, Mr. Holland?
Documented offers withholding court costs.
Okay, Mr. Holland, is that how you wish to resolve your case?
Yes, ma'am.
Then please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Then you can put your hand down. Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of any type of alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional illness? Do you understand the proceedings today?
Yes, ma'am.
Do you understand that you're giving up your right to a trial?
Yes, ma'am.
Are you pleading guilty or no contest to the charges today?
No contest.
And do you understand that if you're not a U.S. citizen and you take a plea, you could face deportation?
Yes, ma'am.
Then, Mr. Holland, I accept your plea. I find that it is freely and voluntarily given, and I sentence you to withhold and court costs. The court will give you 6 months to pay your court costs. Thank you.
All right, thank you.
You're welcome. Jonathan Wadman.
Good morning, Judge. Mr. Wadman's here.
Good morning, Mr. McLawrence. Mr. Wadman, you are facing a municipal ordinance charge, and your attorney is standing next to you. The court does find probable cause. What does he wish to do?
Judge, he would like to resolve this.
Pretrial for criminal mischief. Case number 18093 MM108. We're asking that you revoke the pretrial.
Judge, we can't understand what was said. We can't hear whatever was said in the courtroom.
I know there's a lot of sounds going on. Madam Pretrial, let's try this again.
The client is currently on pretrial for case number 180011943 MM10A for criminal mischief. And as a result of this arrest, we're asking that the pretrial be revoked.
All right, does Mr. Wadman still want to resolve this municipal ordinance matter? Counselors, I'll be happy to recall it if you need some more time. I can't.
You can hear me?
Yeah, now I can. I couldn't hear
Oh,
you.
Judge, what I'm asking the court, based on the fact that he's been reporting that it's a misdemeanor, the new law offense, a city ordinance. I'm asking the court not to take any action on the case, that he's out on pretrial.
Is the request for the revocation based on this new city ordinance?
Yes.
Okay. Then the court will deny the revocation at this time.
Thank you, Judge.
And what's today's date?
All right, sorry.
All right, and then, as to this matter before the court, Mr. McLaurin's, the court will extend the adjudication and time served if that's what he wants to do.
That is what he would like to do.
Okay? So
And just so the court is aware and so the record is clear as well, Judge, I just want the court to know that the item that was taken, it was from a target and it was returned to that target. And I've already explained to Mr. Wadman that he cannot return to the target at 3200 North Federal Highway in Fort Lauderdale.
okay. All right, Mr. Wadman, please raise your right hand. Do you swear or affirm to tell the truth?
I do.
Is anyone forcing you to resolve your case today?
No, ma'am.
You can put your hand down. Are you under the influence of any type of alcohol or drugs?
No, ma'am.
Have you ever been treated for a mental or emotional illness?
No.
Do you understand the proceedings today?
I do.
Do you understand that you're giving up your right to a trial?
I do.
Do you understand that if you're not a U.S. citizen, taking a plea could subject you to deportation?
I do.
Are you pleading guilty or no contest to the municipal ordinance charge today?
No contest.
Then, Mr. Wadman, I accept your plea. I find that it is freely and voluntarily given. The court sentences you to an adjudication and time served. The court will give you 6 months to pay your court costs. Mr. Wadman, you are not to return to the target at 3200 North Federal Highway in Fort Lauderdale. Thank you.
Yes, ma'am. Thank you.
Okay, thank you, Judge.
You're welcome, Mr. McLaurin. Nicholas Anton Knowles.
Judge, I've been informed he bonded.
Thank you. And then the court finds probable cause. Is he represented by the public defender's office? Or he bonded before filling out?
He bonded before he filled anything out.
Andre Akeem Andrew.
Bonded.
The court finds probable cause in absentia. Jason Jonathan Crawford.
North Broward.
Good morning, Mr. Crawford. Good morning.
Good morning.
Mr. Crawford, you're before the court today for trespassing, failure to leave property upon order by the owner. The court does find probable cause. What does Mr. Crawford want to do today?
Your Honor, I keep getting Baker Act every time I leave from here and I post bail, and you guys keep telling me to go home. And every time I speak to my doctors at the Baker Acted office, they ask me, where's home? And I put on a piece of paper several addresses where I can go home. And every time I put on there,
Just let me talk
Okay,
with
Mr.
him.
Crawford,
show up.
hold on, Mr. Crawford. Your
talk to
attorney
him
is
then.
going to speak to you, and then he'll advise me what you want to do, okay?
I'm listed as main jail, Judge, I'm sorry, that's it.
Okay, the deputy will help you, so you can speak with your attorney. And then we'll call it back up when you're ready, Mr. Reedy. Keyshawn Demetrix Ross.
Mr. Ross is here, present at Maine. Mr. Ross, come on up, please.
Good morning, Mr. Ross. You're facing one count of trespassing on occupied structure or conveyance. The court does find probable cause. What does Mr. Ross wish to do?
He wishes to resolve this case today, Judge.
Does the state wish to be heard on Mr. Ross?
No, Your Honor, not until I can do further investigation. Mr. Ross is out right now on grand theft. He's out on another felony case for 2 counts of strong arm robbery and attempted strong arm robbery. He's out on, at least, from what I can tell, from a month ago, he's out on over $12,000 worth of bond.
Well, as to this case that's before the court, I'd be inclined to offer him an adjudication and time served on this matter. I don't know how.
I understand, Judge. Let me advise Mr. Ross of that, but it would be my advice not to resolve. Let me talk to Mr. Ross. Judge, I advise Mr. Ross it's probably not a good idea to resolve this matter. I think Mr. Ross agrees with me for the reasons I advise him. I'm going to ask the court if the court would consider releasing him on pretrial release on this trespassing offense.
The bond will remain at $25 on this matter. Thank you. Ralston Francis. Mr. Francis now is several resets. So,
Yes, ma'am, he's a medical reset today, Your Honor.
Your Honor, I think, well, Mr. Reed's on the phone, but I believe we discussed possibly, based on the information we'd received yesterday, transferring him to Judge Lerner Wren.
okay. Do I need to sign an order to accomplish that?
Well, I just want, Brian, we agreed to transfer
Ralston
to MI.
Francis. He's like a third. So we'll transfer this matter to Judge Lerner Wren's division. Mr. Who?
Bond is kept at 25.
So, yes, I do. I have it. Will the clerk do the transfer or? Okay, you'll let me know. Thank you. Joseph Louise Francois.
Conti?
I believe he has some family, folks.
No, there's no one here.
Good morning, Mr. Francois.
Good morning.
You're before the court today because, are these ad charges?
Yes, these are at charges, Judge. He has, from what I can tell, $25,000 in bonds on other charges with Nebbia and passport surrender, requesting that these bonds be kept in place.
Does the defense wish to be heard?
No, Judge.
Okay, Mr. Francois, the court does find probable cause. There are 2 charges added, and the bonds will remain at $2,500 each. Thank you. Joe Henry Ballard.
Conti again, Your Honor.
Mr. Ballard, good morning. You're also
Good morning, Your
before the
Honor.
court. This is also an ad charge. The court does find probable cause. Does anyone wish to be heard in regards to bond?
Yes, Your Honor, I'm requesting a $50,000 bond on count 2, order of no victim contact. Mr. Ballard is being held no bond on count 1 for burglary with assault or battery. The first appearance court originally found proof evident of presumption great and ordered him to be held no bond on that count. We did file that count as presented, so he is still being held no bond on that count. But I do have concern based on the allegations that he illegally entered this home, went into the juvenile victim's room, and then committed the acts that are alleged before the court.
Friends?
In light of the no bond hold, Judge, I think he's gonna have to go in front of his division judge no matter what.
Right, so the court does find probable cause and imposes a bond of $50,000 as to this new charge. Thank you. And no victim contact. No victim contact.
Your Honor, may I ask who my judge is and if I have a court date?
I don't have that information at this time, so.
I might have it right here,
Oh, okay.
Judge. Your judge is Judge Elizabeth Shearer, and your next court date, you're set for an arraignment on January 14th at 8:45 a.m.
Thank you.
Okay, Arthur et Megjian.
He's here, present, Judge Amain.
Good morning, sir. You're before the court today.
Good morning, Judge.
Count 1, use or display of a firearm during a felony. Count 2, carrying a concealed firearm. 3, possession of cannabis. 4, possession with intent to sell or manufacture or deliver cannabis. 5, possession of THC, and then not for magistrate, the tinting on your car. The court does find probable cause. Does anyone wish to be heard as to the bond?
Your Honor, Lily Wong on behalf of the state. As to charge 1, use or display of a firearm during felony, the state suggests a $1,000 bond.
Okay, you've been quiet over there.
Good morning, Your Honor.
Okay, good morning. Does the defense wish to be heard?
Judge, and speaking Mr., how do you pronounce your last name again, sir?
Ekmekjian.
With Mr. Ekmekjian?
No, second good.
Judge, Mr. Ekmekjian is asking the court if the court would consider releasing him on pre-trial release. He's 21 years old, been here his whole entire life. He does work, he advised me, he is a farrier. I did not know what that was, and he advised me, he basically removes horseshoes. He works in Wellington. He's been doing that for 1 year now, in which he gets paid approximately $75 per day. He lives in Loxahatchee, which is in Palm Beach. He lives with his mother, and unfortunately his mother is on disability, so that's why he believes it's going to be a great financial strain for the family in order to come up with the monetary bond. And that is why he's asking me to ask the court if the court would consider releasing him on pretrial release.
Your Honor, I would just note, looking at, he did have a failure to appear in 2017 in Palm Beach. And as far as financial ability, I checked, he is the registered owner of the 2015 BMW that he was driving when he was stopped by law enforcement.
Thank you. As to count 1, use and display of a firearm during a felony, the court will impose a bond of $1,000. The remaining counts will remain at $1,000. Thank you. Samuel Braden Boyer.
Mr. Boyer, come on up, please.
Morning, Mr. Boyer. You're before the court today for count 1, a petty theft, count 2, resisting officer without violence, and there's also an out-of-state felony hold. The court does find probable cause. I believe you will be going before an extradition court. Is there, yep. So what does, Mr. Boyer want to do, if anything, with, the
Nothing at this time, Judge.
All right, then, the court will not impose a bond on count one. Count two, the resisting officer without violence will remain as a $100 bond. Thank you. I don't want to mess this name up, so the last name is EYMA.
He's a medical research, Your Honor.
Thank you. How about Kelvin R. Lanier?
No problem. Good morning, Your Honor.
Good morning, sir. You're before the court today. Count one, aggravated battery with a deadly weapon. Count two, possession of ammo by a convicted felon. The court does find probable cause. Does anyone wish to be heard as to the bond?
Judge, Mr. Lanier is not going to be able to make a $50,000 bond. I've reviewed the warrant, and I understand that, the allegations are very serious, but Mr. Lanier is still presumed to be innocent of these offenses. And, Mr. Lanier, what can you afford in bond?
Okay, right now, I'm actually finna be fired, so I can't afford anything right now.
Thank you. As to the bond, count one and two will remain $25,000 each. Thank you.
Your Honor?
Yes.
I'm sorry, before he leaves, we would also be asking for an order of no victim contact.
I did have that. No contact with Denisha Miller.
Yes, ma'am.
Thank you. Shaddai McLeod. Shaddai McLeod.
Mr. McLeod is here at Main, Judge.
Good morning, Mr. McLeod. You're before the court today for count one of a burglary of an unoccupied dwelling unarmed. The court does find probable cause. Does anyone wish to be heard as to the bond?
Your Honor,
Judge.
we can just have one moment. If Mr. Romero wants to proceed, though, obviously that's fine.
No problem. Judge, he's 18 years old, been here his whole entire life. He's not working, he's going to school. He's a senior at Siegel. Right now, he's set to graduate this upcoming year. He lives in Sunrise with his parents. His mother and father basically, his father is the financial breadwinner of the family. He supports the whole entire family, and he has 10 siblings, Judge. His mother is a stay-at-home mom. Very hard job in taking care of basically her 11 children. Right now, their financial resources are quite limited. Judge, I'm going to be asking for the court to, I realize this is a burglary of a dwelling, but since Mr. McLeod's family doesn't have the financial resources to put up very much of a bond, so I'm going to be asking the court to impose a $1,000 bond along with pretrial release so he could be supervised, Judge.
Your Honor, the state's going to be requesting a $20,000 bond, pretrial release with a GPS monitor. The state is very concerned for the community, considering this was someone's home. If I could also have a moment, I would like to print out his juvenile record, including the cases that he's currently on conditional release for, because I think they need to be taken into consideration when setting an appropriate bond and release conditions for Mr. McLeod. And if I just have a moment, Your Honor, it's preparing the report to print out right now.
Thank you. All right, thank you. The court does find probable cause as to discharge Mr. McLeod, and the court will impose a $5,000 bond in addition to a level 2 GPS under pretrial services. Thank you. Kendrick Demetric Hardy.
He's approaching at Main.
Can I get the paperwork back just real quickly? On Mr. McLeod, is he still there?
He just stepped out, but we can have him brought back.
Can you just so I can tell him no return?
No problem. Mr. McLeod? They're going to get him right now,
Thank
Judge.
you.
He's here. Come on up, Mr. McLeod.
Mr. McLeod, I just want to let you know that you should not return to the property at 1401 Northwest 6th Avenue in Fort Lauderdale. No return to that location, sir. Thank you.
Yes, ma'am.
Thank you. All right, Mr. Hardy. Mr. Hardy, you're before the court today on a resisting officer without violence. There's a $100 bond set. You've got three felony cases, and then there is a violation of probation. The court does find probable cause, and the bonds will remain the same, and it looks like you should be going to your felony division judge on January 14th. Thank you.
Your Honor, could we recall Mr. Crawford from North Broward?
Let's see. Yes, we can. North Broward. Mr. Crawford, okay? Mr. Reedy, you have had an opportunity to speak to Mr. Crawford?
I have, Your Honor, and I'm going to be requesting that the court transfer this case to Judge Lerner Wren's Mental Health Division.
Then the court will transfer to mental health. Thank you.
Every time I get transferred to the mental hospital, they ask me to go home, and I put down several addresses of home. And every time I tell them this is where I'm gonna go home at, I go to that address, and I still don't able not to go home. I get into arguments, and then they call the police and say it's trespassing, and I end right back up here with $1,000 bond every time.
Okay,
I'm
Mr.
homeless.
Crawford,
I am homeless. I want to go home. I have a dad that I can try to go to today, and I think I can make a change with today. I'm going to go home to him and see if he'll help me, because I have tried this several times, Your Honor. And every time you tell me to do the same thing, we're going to do the mental hospital, and every time you do the mental hospital, I tell the mental, I don't even have insurance. How's these people paying for my medication?
Okay,
I
Mr.
take
Crawford.
Zyprexa and I take Adderall every day.
Mr. Crawford, they'll take care of you. Judge Lerner Wren will take care of you over in mental health court, okay?
Sorry.
She'll help you straighten all this out.
All right. Justin Lee Fulton.
Mr. Justin Fulton, he's here at Main.
Mr. Fulton, you're before the court today. There's a misdemeanor capias, and then there's a felony violation of probation. The court does find probable cause. You should be seeing your felony judge on January 14th at 8:30. Thank you. Matthew Carlos Anderson.
He's here, President Main Judge.
Good morning, Mr. Anderson.
Good morning.
You're before the court today for driving while license suspended, third or subsequent offense, and attaching registration license plate not assigned, and then then there's a traffic violation, not for magistrate. The court does find probable cause.
Judge, I'm going to be asking, I'm sorry.
Go ahead.
Mr. Anderson, when he was arrested, he had $100 in his property. I'm going to ask that the court consider reducing the bond from $750 to $100 so he can self-bond. If in the alternative, if the court's not inclined to do that, then I'm going to be requesting a phone order so then he could have access to his contacts, so then he could call his friends and family to go to a bondsman and help post his monetary bond. And that is the defense request.
Okay, Mr. Anderson, the court will set your bond at $100. I did say the court found probable cause and will set the bond at $100. Thank you.
Thank you.
Wilner Ogos. I don't want to butcher these names. Ogusse.
Judge, I've been advised he's in court in Judge Yusan's courtroom.
Okay.
Are you in bed?
That's August for the, August is for a reset. Yes. Then Gabriel Jean.
Gabriel Jean is here present, Judge. From what he informed us, he has private counsel.
I spoke with his attorney, Judge.
Okay.
And she indicated to me she has not yet been retained on the case, but she is asking if the bond could be set at $1,000 on count one.
What's the name of the attorney, Mr. Reedy?
It is last name is Elizabeth Esta.
Okay.
Out of Dade County.
Okay. So, Mr. Jean, there's attorney Esther who's indicated, I guess your family's speaking with her to retain her. The court does find probable cause as to both counts. As to count one, the court will set the bond at $1,000, and then count two on the grand theft, the bond will remain at $1,000.
Thank you, Your Honor.
That's it?
Alfonso Samuel Walker.
Judge, Mr. Walker is here present at Maine. He declined the services of public defender.
Okay, good morning, Mr. Walker. You're before the court today for possession of cannabis over 20 grams. The bond is $1,000. Count two, possession with intent to sell or manufacture or deliver cannabis. Then you have some traffic violations, not for magistrate, failure to wear seatbelt, and then you also are on a probation violation. So the court does find probable cause. As to counts one and two, the bonds are $1,000, and you should be seeing your felony judge on January 14th at 8:30.
Thank you.
You're welcome, sir. Then we have John Haynes.
Morning, ma'am.
Good morning, Mr. Haynes. You're
Morning, ma'am.
before the court today for unauthorized possession of stolen driver's license, operating without a valid driver's license, and then not for magistrate, a speeding ticket. So the court does find probable cause. Does anyone wish to be heard as to the bond?
Yes, Judge, I'm going to be requesting Mr. Haynes be released, either ROR or in pretrial. Before I proceed, I'll see if the state has an objection to that.
Your Honor, the state does have an objection to that.
Okay, in that case,
Okay,
Judge,
so his bond has already been posted.
Oh,
Thank you.
thank you.
Mr. Haynes. What do you have?
Just the appointment order of Jonathan Watts. So Judge, the last case on the court's docket is Vernon, or the next to last case on the court's docket is Vernon Coleman. He was a medical reset from yesterday.
Right.
And I was informed that Mr. Coleman is in courtroom 6780. He'll still need to be magistrated.
Yes.
So I guess you could reset him for tomorrow.
All
Or
right.
you reset him for the afternoon. I'm not sure which one you would do.
Thank you, Mr. McLaurin. Will we be able to get him here this afternoon? Vernon Coleman. Let's reset it for tomorrow, so we make sure. Thank you.
You're welcome, Judge.
Is that the only thing you're here for, Mr. McLaurin?
Yes, Judge. Judge, could I approach first on the matter?
Certainly. Greg Allen Dickerson.
He's here, present, Judge.
Mr. Dickerson, good morning. You're before the court today on count 1 of a grand theft. The court does find probable cause. Does anyone wish to be heard as to the bond?
Yes, Judge, Mr. Dixon is financially indigent. He's homeless, he's 40 years old. There's nobody that he told me that posts his monetary bond. He's asking the court to consider releasing him on pretrial release.
I'd also point out he's $6.04 away from a misdemeanor.
And then, Your Honor, we would be objecting to the pretrial release, just so that the court is aware. Mr. Dickerson did have a failure to appear at arraignment, and a no bond KPS was issued, and he was ROR'd on January 7th of 2019, so that was this Monday. And then back in 2018, August, he also had a failure to appear with a KPS issued.
Thank you. The court will release Mr. Dickerson to standard pretrial services. Thank you. Supervision.
Judge, if he doesn't get out today in order to report, on weekends, pretrial is closed, so he'll have till Monday, 12 noon to report?
That is correct.
Thank you, Judge.
Thank you. Omar Antonio Pena.
He's here, Judge.
Mr. Pena, you're before the court today on count 1, possession of cannabis over 20 grams. Count 2, possession with intent to sell or manufacture or deliver cannabis. Count 3, possession of oxycodone. And then not for magistrate, unlawful speeding. The court does find probable cause. Does anyone wish to be heard as to the bond?
Not from the defense, Judge.
Okay, the court will impose the bond, at $1,000 on count 1, 1,000 on 2, and 1,000 on count 3. Thank you.
I'll call your sister afterwards, okay? Good luck, sir.
We've had some folks sitting in the courtroom. Are there attorneys or do we know? Okay. Or who are you waiting for? But there's someone else here on my signing sheet. What's the name? All right, then we'll keep going just so we're almost at the end, so we'll get to it. Just so we. Alvin Kenosis Kelly.
Mr. Kelly, come on up, please.
I've been advised that Mr. Kelly's bond has been posted, so the court does find probable cause and his bond has been posted. Thank you. Errol J. Baloney.
Come on, Mr. Bellamy.
Mr. Baloney, you're before the court today for a driving while license suspended habitual. Court does find probable cause. And
Judge, I'm going to be requesting the court consider releasing him on pretrial release. My understanding is he is employed. He works at a company called ICOR at their call center. He's been there for 2 years. He's already missed work today. He's scheduled this Sunday. He doesn't want to risk jeopardizing that employment because right now he's making $11 an hour there. He's 22 years old, been here his whole entire life. He lives in Margate with his parents. So he's asking for the court to consider releasing him on pretrial release.
And then, Your Honor, the state would be objecting to that, and we'd actually be asking for an increased bond of $2,500. This lady, Your Honor, has gentleman, Your Honor, has actually 4 open cases, 3 DWLSs, as well as a felony arrest with Judge Cora that he was just arrested on December 18th.
thank you. The bond will be imposed $750. Thank you. Alfonso McGee.
Mr. McGee is approaching, Judge.
Mr. McGee, you're before the court today for 1 count of possession of cocaine. The court does find probable cause. Does anyone wish to be heard as to the bond?
I do, Judge. We're asking for pretrial release. He's 55 years old, his whole life. He does work, he does landscaping, he gets paid by the day. He gets average about $60 per day. He lives in Dania Beach with his mom. And my understanding, the way that they pay for rent, they're on housing. So financially, he said his mom cannot afford to post his monetary bond. Considering this is a drug offense and nonviolent offense, we're going to be asking for the court to consider releasing him on pretrial release.
Your Honor, the state would be objecting to that, and we would be asking you to keep the bond at $1,000, Your Honor. Mr. McGee actually was just released from prison in 2017. He has a case of possession of cocaine back in June 29th of 2018, as well as a felony possession of cannabis that he served 34.2 months for. And also another 2014 possession of cannabis felony, 34 months, and then a 2013 possession of cannabis, less than 20 grams, also with a resisting of violence. Another 2013 possession of cannabis with intent to sell, and then another 2013 possession of cannabis with intent to sell, a 2012 possession of cannabis misdemeanor.
Thank you.
Your Honor, sir.
Thank you.
Judge, I realize Mr. McGee has a lengthy record, and I, from what I heard correctly from the state, is that he's currently out, I believe, on a drug offense. So what I'd be suggesting, Judge, no one's still going to be able to post his bond. I'm going to be asking once again for a pretrial, but this time with added conditions. I'm going to be asking for basically a drug examination as far as monitoring and any random testing. At least that way, he'll be supervised and the court will know through pretrial if he's consuming in the future. So we're going to be asking for a pretrial with those conditions, Judge.
Thank you. The court does find probable cause. Mr. McGee will be released to pretrial supervision. There shall be no drugs or alcohol. He will be subjected to random drug testing. Thank you. I'm sorry?
Yes, sir. Pretrial, go today if they're open. If they're not, tomorrow before 12 noon. All right? All right, thanks.
Daniel Joseph Azamar.
Mr. Azamar is here present. Judge Amani is approaching, and we're going to be waiving formal reading of all the charges.
Good morning. Who do we have in the courtroom? Ladies, can you please announce?
His sister.
Okay, if you'll go one at a time, all right, and just speak in the microphone, please just state your name if you want to be heard.
Yes, I'm his wife,
What's your name?
Evelyn Sol.
Okay? Anybody else who's
My
going to speak?
brother-in-law,
What is your name, ma'am?
Melin Trazilian.
Okay,
His sister, Rosette Azamar.
okay. Mr. Azamar, the court does find probable cause, and you do have family members in the courtroom. Have you retained an attorney for? Okay.
He signed up with the public defender's office this morning,
Yes.
Judge.
Okay, so then I'll hear from the attorneys in regards to the bond.
Thank you, Your Honor. With regards to count one, I'm going to be requesting a no bond hold upon the finding of proof evident or presumption great for first appearance purposes on this punishable life offense. I would note, according to the probable cause affidavit from Detective Graber, it mentions the statement given by the alleged victim that goes into great detail about what took place. Additionally, forensics obtained previous communications and messages between both parties, in which Mr. Azamar acknowledges and admits to the allegations. There's also other statements he makes corroborating the victim's allegations. Lastly, I would note, Your Honor, that Mr. Azamar, post Miranda, confessed to these allegations. This confession was audio and video recorded, and the probable cause affidavit gives specific details as to his confessions.
We would object to the court making a finding of proof evident and presumption great at this time. I have reviewed the probable cause affidavit in the case, and I would remind the court that proof evident presumption great is the highest standard of proof that we have in the criminal justice system, higher even than proof beyond and to the exclusion of every reasonable doubt. At this point in the proceedings, no evidence has been produced before this court, no witnesses have been called. The state is asking this court to hold Mr. Azamar without bond and is relying on details outlined in a probable cause affidavit, which is a document written by a detective to justify the charges against Mr. Azamar. If the state really was serious about proving proof evident presumption great and establishing that very high standard, they would have brought this statement in for the court to listen to. Instead, they did not. They've called no witnesses. They produced no evidence. And I would submit to this court that relying on this probable cause affidavit in order to establish proof evident presumption great is not appropriate. However, if over our objection the court does find proof evident presumption great, I would ask the court to take testimony from the family or whatever it is that they would like to say, and whatever Mr. Romero has to contribute as well. And I'd ask the court to exercise its discretion and set bond for Mr. Azamar.
Your Honor, I would just first note, the defense's claim that proof evident or presumption great is above, beyond a reasonable doubt, is not supported by the case law, certainly not by the 4th District Court of Appeals, which has defined proof evident or presumption great and never stated that it is above, beyond a reasonable doubt. Secondly, under the 4th DCA, under ISAZA, has already held, and Mr. Reed is aware of this, that the state may rely upon affidavits to support a finding of proof evident presumption great. I would note in that specific case, the state relied solely on a probable cause affidavit. I know this because I argued the first appearance on that case.
State, Yasvazi v. State does not require the court to rely on a probable cause affidavit. It allows the court to do so under very certain and specific circumstances where the probable cause affidavit rises to that level. My submission to this court is that this probable cause affidavit does not do so, and proof evident presumption great is the highest standard we have in the criminal justice system, period.
Again, Your Honor, ISAZA states, it doesn't state what the court can and cannot. It states that the state may rely upon an affidavit. And for Mr. Reedy's argument to be accepted, that would mean that the state cannot rely upon an affidavit if we were required to bring in additional evidence. And that would be against the 4th DCA's ruling.
It is a case-by-case analysis.
Thank you. At this time, the court will not make that finding of proof evident presumption great as to count 1.
Then, Your Honor, the state would ask for time.
Oh, okay.
And, Your Honor, it's just so I can advise the detective, is there any particular reasons why the court is not finding proof evident or presumption great on a probable cause affidavit where the defendant has confessed on video and audio tape, where there are social media messages where he has confessed to committing these offenses, and a sworn statement was taken from the victim?
Well, if you want to bring more information, or whoever you want to bring in to testify, will that person be available this afternoon? Do you want?
I don't know, Your Honor. The state's entitled to 24 hours, so
Yeah,
I'm requesting
so-
24 hours.
So I will give you 24 hours to do so.
But, Your Honor, but since you won't be here, and since I have to instruct the detective how to possibly perfect, I need to know what the court is specifically finding about this information does not satisfy proof evident or presumption great. Because if I don't know, then I don't know how I can perfect.
All right, well, let's put this matter to the end, and I will let you know. Ladies, will you please have a seat, and then we'll come back to this. Thank you.
Thank you.
What time is it? We still have time. Okay. Sean Michael Serbay.
Mr. Survey is here. Come on up, Mr. Survey.
Mr. Serbay, you're before the court today for count 1, grand theft, count 2, resisting officer without violence, and felony probation violation. The court does find probable cause. Mr. Serbay, the bond on count 1 for grand theft will remain as $1,000. The court will not impose a bond on count 2. And you should be going to your felony division judge January 14th at 8:30. Mark Alexander Herman.
Mr. Herman is here, present judge at Maine. Come on up, sir.
Mr. Herman, you're before the court today on count one, burglary of an unoccupied dwelling unarmed, and count two, petty theft, first offense. The court does find probable cause. Does anyone wish to be heard as to the bond?
Your Honor, we'd be asking for charge one. It is a burglary of an unoccupied dwelling of someone's home, so we'd be asking for 15,000.
Judge, $15,000 is simply something Mr. Herman does not have. Unfortunately, I did not review the PC affidavit, but I believe the dwelling that the PC affidavit is referring to is the home of Mr. Mark Herman's parents. My understanding is Mr. Herman basically still has some of his belongings at that residence. I believe he still actually has a key from that residence. So I'd ask you to take that into consideration for mitigation purposes. He's right now looking for work. He's unemployed. My understanding, and I'm sure the state will correct me if I'm wrong, this is his first arrest. He's a registered voter here in Broward County. At this time, Judge, he's basically homeless. So there's nobody that's going to post his monetary bond. So I'm asking the court to consider releasing him on pretrial release.
At this time, the court will impose a bond of $1,000 on Mr. Herman's case. Thank you. Brian Ariel Montenegro.
Mr. Montenegro is here present, Judge.
Mr. Montenegro, you're before the court on a trafficking amphetamine, 200 grams or more. The court does find probable cause. Does anyone wish to be heard as to the bond?
Judge, $250,000 is something Mr. Montenegro does not have. He's not from South Florida. He's only been here for 2 days. He's from Los Angeles, Judge. He works there. He rents an apartment there. His monthly rent is about $400 that he shares with roommates. He works, he's a roofer. He gets paid about $16 a day. Now, he does have a family that he's going to be reaching out to that work in construction, but the $250,000 is something his family doesn't have either. My understanding, Judge, is I believe he has a clean record. I'd be asking the court to enter an order allowing him access to his phone so he can contact a family to help post his monetary bond. But I'm going to be asking something reasonable considering Mr. Montenegro's financial resources. I'm going to be asking the court to impose a $10,000 bond.
Does the state wish to be heard?
One moment, Your Honor.
Your Honor, we would ask that the bond be kept in place. If convicted of this charge, it's a 15-year minimum. Mandatory prison sentence.
Thank you. At this time, the court will impose a bond of $10,000. Thank you, Mr. Montenegro.
And the court will sign a phone order?
And the court will sign a phone order.
Thank you, Judge.
The court's gonna take a recess, like a 10-minute recess. Thank you. record. Walter Andrade Fuentes.
Judge, we don't have a
Mr.
clerk.
Andrade is here present, Judge.
We don't have a clerk.
Oh, all right. We'll wait for the clerk to return.
Guess so.
No problem, thank you. All right, then we're Walter Andrade Fuentes.
He's here.
Was Mr. Fuentes, is he a co-arrestee? Somebody handled before?
I believe so, Judge.
Mr. Fuentes, the court does find probable cause as to trafficking in methamphetamine 200 grams or more. Does the parties wish to be heard as to the bond?
Yes, Your Honor. Your Honor, I'm requesting that the bond be kept at $250,000. First off, if convicted of this offense, he faces a 15-year minimum mandatory sentence. Also, there appears to be no information, personal information, identification information, as far as Mr. Andrade Fuentes. His address is listed as unknown. It states he's born in Mexico, but there's no other additional information, no social security number. We don't even know if this is his actual name. Your Honor, he has no incentive to return to court. I would note his co-defendant resides in California, and I would note, at a minimum, the street value of the methamphetamine that they came here to deal was over $36,000. So it would appear that they are substantially involved in drug dealing.
What was the bond imposed on the previous?
Well, Your Honor, it was $10,000.
10, right?
Yes, Your Honor. I did not make argument in that one, but I would have been asking for $250,000 to be kept on that case as well.
Defense? Yeah, I'm sorry. He has an immigration hold.
So it would appear he does have a lack of ties to the country.
Okay.
Judge, that's what Mr. Andrade did tell me. He has an immigration hold. It is true that he's right now has no ties to Florida. However, he's been residing in Georgia for a number of years. He works as a roofer. He gets paid about $20 a day. He has other family members that work in Georgia. He, I believe, lives in a suburb of Georgia called Gonesboro. He lives with roommates where he's been renting at the same premises for 1 year, and his portion of the rent is $300. Judge, having said that, I do realize he has a probation hold, so this is not going to be released anyway. But $250,000 is just something unreasonable.
At this point in time, the court will impose a $10,000 bond on this case, and noting that Mr. Andrade Fuentes also does have an immigration hold. Thank you. Jeff Fontilos,
Mr. Fontillis, come on up, please.
tell us. Mr. Fontilos, you're before the court this morning for grand theft. The court does find probable cause. Does anyone wish to be heard as to the bond?
Yes, Judge. My understanding, this is his first arrest ever. He has a clean record. He's 32 years old. He lives with his family in North Miami. If the state can confirm this is his first arrest, and this is a nonviolent offense, I'm going to be asking the court to consider an ROR. I'll see if the state has an objection to that.
No objection to pretrial, Your Honor.
We're going to be asking then the court to consider releasing him a straight ROR. Judge, considering this is a nonviolent offense, and I believe by it's been confirmed, a clean record.
Thank you. Mr. Fontilos, the court will release you to the standard pretrial supervision. Thank you.
Judge, in that case, respectfully, if the court's not inclined to ROR, then we're going to be asking the court just to leave the bond in place, and he's going to reach out to his girlfriend to post his bond.
Okay, then the bond will remain in place. Thank you.
Thank you.
Cesar Rivera.
Mr. Rivera is here present, Judge. Come on up, sir.
Mr. Rivera, you're before the court today for possession of heroin. The court does find probable cause. What's his estate? Mr. Bond?
Your Honor, we would ask that the bond be kept in place for $1,000. Mr. Rivera does have a history. In 2007, Your Honor, he was in possession of cocaine, as well as in, Okay, and Your Honor, which was found not guilty, and then in 2004, Your Honor, he has a resisting without violence with a trespass and a 2001 robbery with a weapon, aggravated battery, and he served 364 days and 5.5 years for the robbery with a weapon.
Judge, I'm going to be asking for the court to consider releasing him on standard pretrial release. As you heard, is quite dated, his offenses. He's 33 years old, been living here his whole entire life. He works 7 days a week, basically supporting his wife and his daughter. His wife is a stay-at-home mom, taking care of their 7-year-old daughter. They rent an apartment locally here in Hollywood. Without Mr. Rivera working to support the household, my fear is that, unfortunately, the family is going to become homeless. Considering this is a non-violent offense, it's a drug offense, Judge, the likelihood of this not being filed in time and then ultimately he's going to be released ROR with no supervision is a real possibility. So therefore, I'm asking the court to consider releasing him on pretrial release at this time so then he could be out working, supporting his family, and being supervised.
At this time, the court will impose standard pretrial supervision. Mr. Rivera, you must report to pretrial services. It is Friday, so you have until Monday if you're not able to get there today in time. Thank you.
Thank you. Thanks, Judge.
Luis William Lamboy.
Mr. Lamboy? Mr. Lamboy. Mr. Lamboy. Lamboy. Come on up, sir.
Mr. Lamboy, you're before the court today. Count 1, possession of a controlled substance without prescription. Count 2, possession of alprazolam. and not for magistrate speeding. The court does find probable cause. Does anyone wish to?
Judge,
Yes.
sorry.
Go ahead.
My understanding, Mr. Lamboy has a clean record. If the state can verify that, I'm going to be asking for a straight ROR.
Your Honor, we would object to that. Even though Mr. Limboy doesn't have priors, we would be asking for a pretrial release.
Thank you. This time, the court will release Mr. Lumboy to standard pretrial supervision. Thank you.
Thank you, Judge. I will go ahead and give him a map.
Matthew David Archer.
Make sure you report. You're getting released, but make sure you report. All right. Good luck, sir. Judge, he's here present. He declined the service as public defender.
Well, no, I have a private attorney. His name is Mitchell J. Beers out of Palm Beach Gardens.
Go look it up.
With that, I was never given a phone call or anything as of yesterday.
Okay, Mr. Archer, you're before the court for count 1, grand theft, and count 2, possession of THC. The court does find probable cause, and the bonds in place, $1,000 on each count. Thank you.
May I speak, Your Honor?
I wouldn't say anything if I were you, Mr. Archer. I spoke with your attorney, Mr. Beers. He advised you to remain silent.
And I will take his advice. And Judge Podwell, thank you for your time, Miss Powell.
You're welcome, sir. Romeo Kendi Medward.
He's approaching, Judge. He's approaching.
Thank you. Mr. Medward, you're before the court for possession of MDMA. The court does find probable cause. Does anyone wish to be heard as to the bond?
Judge, I'm going to ask the court to consider releasing Mr. Medward, ROR. He's 26 years old, been living in our community since 2009. He's currently working at a company called Central Air Conditioning, where he's been 2 years making $14 an hour. He lives in Palm Beach locally here with his mother. I understand. Hold on. He has a clean record, and if the state can verify that, I'm going to be asking the court to consider an ROR on this nonviolent offense.
Your Honor, I'm requesting release to PTR.
Thank you. The court's going to release Mr. Medward to standard pretrial release. Thank you.
I'll give him the map, Judge.
Bruce Howard Johnson.
He's coming up, Judge, and he wishes to proceed.
Who is that?
Judge, he's here present, Mr. Johnson.
Okay, can we go back just to Mr. Medward?
Yes, hold, have a seat. I believe Mr. Medward, come on up. I think maybe somebody posted your bond. Yes, I don't know. He's approaching, Judge.
Mr. Medward, I've just been advised by the confinement status that your bond has been posted. Okay? So my previous order to pretrial release is no longer that order. Your bond has been posted.
Thank you, Judge.
Bruce Howard Johnson.
Mr. Johnson's here present, Judge.
Mr. Johnson, you're before the court for count 1, false ID given to a law enforcement officer. You also have trespassing, and there is a felony probation violation. So the bond for $100 will remain in count 1, and you should be seeing your felony judge January 14th at 8:30. Thank you.
Judge, if I may be heard, I spoke with Mr. Johnson, and I believe the new law offense is a misdemeanor offense. He's going over to see his judge this upcoming Monday. I believe odds are it's going to be a good chance that Mr. Johnson may have that no bond hold lifted. In saying that, Judge, considering this a misdemeanor offense, I'm going to be asking the court to consider an ROR, and that's basically taking a chance. And the reason why is if the court doesn't feel as far as it's appropriate to release that no bond hold, then he's not going to be getting credit. He does realize that, but that's why I'm asking for an ROR at this time, Judge.
Just
On count one alone.
That'll be denied at this time, Mr. Romero. Thank you. Jeffrey Leroy Reese.
Mr. Reese is here.
Mr. Reese is before the court today on trespassing on occupied structure or conveyance. And then there's two felony violation of probation counts. The court does find probable cause.
And Judge, Mr. Reese is also requesting on count one alone on the trespass. It's a $25 bond. He's going to see his felony violation probation judge on Monday. We're requesting an ROR on Mr. Reese's behalf on count one alone.
That's denied. The bond will remain at $25. Thank you. Steve Hippolyte.
He's a medical research, Your Honor.
Okay. Eddie Ribolo.
North Broward.
He's here today.
Yes, ma'am.
I did speak with him. He is, I believe.
No problem.
Okay, Mr. Ribolo, you're before the court today for grand theft auto, driving while licensed, suspended habitual. You have 3 out-of-county felony holds, and then there is count 6, a petty theft. The court does find probable cause. I think we did, no, we didn't. The court finds probable cause, and the bonds will remain $1,000 count 1, $750 on count 2. There's the out-of-county holds and felony that's not for magistrate, and then your petty theft. Thank you.
Who is my judge, Your Honor?
Didn't I just tell you that?
I don't remember, sir. I couldn't hear you clearly.
Signed to Judge Colra.
Judge
That's
Kohler.
what I told you. It was Judge Colra.
Colra?
I told you twice.
Then we have Mr. Sanlis. Sanlis?
Research, Your Honor.
Okay.
Yep. Yes.
All right. Then we can go back to,
I'm sorry, Your Honor. Well,
I'm
I just
sorry?
wanted to confirm, was he medical or did he refuse? Because I know yesterday he refused.
No, he was a medical reset today, Mr. Member.
Thank you.
all right, then we can go back on to Mr. Daniel Joseph Azamar.
He's here, our main judge.
The court has had an opportunity to review the file and to review the case law. And at this time, the court is going to find that proof is evident. However, I am going to exercise my discretion to impose bonds on these matters. So as to count 1, the court will set the bond.
Your Honor, I would ask to be heard as far as bond.
Oh, I thought we had that before.
No, we
Okay,
didn't.
no.
Well, I didn't, because
Go
I was
ahead.
seeking a no bond. Your Honor, on count 1, punishable by life offense, I'm going to be seeking a $250,000 bond. Your Honor, not only based on the strength of the evidence, but the allegations that he committed these acts against his own student in school, and that it occurred in the classroom itself, Your Honor. On counts 2 through 13, I'm going to be requesting bonds in the amount of $25,000 per count. I'm going to be requesting pretrial release with a GPS monitor level 1, no contact with the alleged victim, DP, no contact with any minors. And nothing further. No possession of any devices with internet access, Your Honor. I know. First, I just want to note Mr. Sanders argued the Supreme Court case with regards to this issue, and I would note, Your Honor, I've reviewed that case law. That case had to do with a state statute that made it unlawful for registered sex offenders to ever access certain social media websites. That is distinguishable from making it a release condition, which in its very nature is temporary, either until further order of the court or until the case is ultimately resolved. So I would argue that the case law that Mr. Sanders relied upon yesterday, and I don't know if the court took that into consideration in the case yesterday, not imposing a condition that the defendant not be in possession of any devices with internet access, is clearly distinguishable from what I am requesting of the court today, and that it is relevant considering that there was communication via social media between the alleged victim and Mr. Azamar.
Thank you. Mr. Reedy, do you want to be heard again?
Yes, Judge, I would object to the court imposing that condition. Mr. Azamar is not a registered sex offender. He's not been convicted of any crime. And as Mr. Saunders pointed out in the case we had yesterday, access to the internet is essential for living a life today. You can't get by without it. So I would object to the court imposing that condition.
Thank you.
Judge, one other thing, my understanding is this is Mr. Azamar's first contact with the criminal justice system. He's a registered voter here, a member of our community. He's 34 years old, been here majority of his life. He lives in Lauderhill. First, he appreciates his family being here for the support. And contrary to what the state said before, he is looking forward to having his day in court, and he will be coming back in court to face these allegations. He lives with his wife. They live in a condominium in Lauderhill where they've been residing for the past 3 years. My understanding is that they do not own it, they rent. And I believe the rent is approximately $925 per month. Now, his wife is employed. I believe she is a caretaker, and he's going to be reaching out to his wife, his family, to help post that monetary bond. But the bonds which the state has suggested is just something financially that Azamar does not have, nor his friends, nor family. Judge, we do not object to having Mr. Azamar being supervised by pretrial release. But the monetary bond is something that we want to concentrate on. The $250,000 alone on count one is something that he cannot afford. We're going to be asking the court to consider reducing that from $250,000 to $25,000. On every subsequent count, we're going to be asking for $2,000 bond. I believe that monetary amount, along with supervision, is something reasonable for a person who's presumed innocent, his first contact with the criminal justice system, his lengthy ties to the community, not his friends and family, or also live in our community, Judge.
Thank you. The court does find probable cause, well, I said that already. The court finds the proof is evident and is using the court's discretion to set a bond. As to count one, the court sets the bond at $100,000. For all the remaining counts, 2 through 13, the bond is $25,000. If Mr. Azamar is posts the bond, there will be he'll be placed on level 1 GPS. Mr. Azamar, you shall have no contact with the alleged victim, DP. There shall be no contact with any minors, and there shall be no access to any electronic device. Thank you, everyone.
And Your Honor, just for clarification, we're talking about devices with internet access?
I'm sorry. We live in an electronic world, so no internet access.
Thank you, Judge.
Thank you. Thank you, ladies. Is it? Is there anything else that we have pending before the court this morning?
And from the state.
Thank you. Then the court will be in recess until this afternoon. Thank you.